2311. Racing and Front Row Motorsports are suing NASCAR in an antitrust lawsuit. What does this represent for the 2025 season? Neither franchise has signed the charter agreement for 2025, although both are expected to field up to 3 teams next season. Could this turn out to be a huge problem for NASCAR and the teams? There is one key reason why 2311 Racing and Front Row did not sign the charter agreement. NASCAR added a condition to the deal, which it presented at the take-it-or-leave-it deadline at the end of the regular season, requiring teams to waive their rights to file an antitrust action against the sanctioning body. So how will these 2 teams compete next year? As open teams? Not likely. At least not unless they have to. The team's complaint, filed on Wednesday, seeks a preliminary injunction. A preliminary injunction is a court order that prohibits the defendant, in this case NASCAR, from engaging in the claimed damaging action. The harm here is 2311 and Front Row giving up antitrust rights, something which they refused to do at first. According to the complaint, 2311 and Front Row want the court to grant a preliminary injunction to void Section 10.3 of the Charter Agreement for the duration of this action, lawsuit, and obtain relief to which they are entitled under the antitrust laws while continuing to compete as a chartered team in the relevant market. In other words, both groups will sign the agreement, but the antitrust portion will be excluded. Depending on the outcome, the antitrust regulation will be sustained or declared invalid. While 2311 Racing has declared that they would honor their promises to their sponsors and teams, it will not be simple. Without the preliminary injunction, 2311 and Front Row would not sign the charter agreements, and you'd be talking about open cars. It would be extremely expensive to race with 3 open cars. The NASCAR Cup Series isn't designed to accommodate open teams, at least not for a full-time season. Without a charter agreement, 2311 and Front Row would be ineligible for any compensation other than prize money. That implies no TV money and no performance bonuses from year to year. All of this would be gone. If 2311 Racing and Front Row Motorsports intend to race full-time next year, the preliminary injunction must be granted. Otherwise, this procedure becomes far more costly for these 2 businesses. 2311 didn't file this case for no cause. They believe they can win and revolutionize NASCAR. The same applies to Front Row Motorsports. This will be a crucial case, no matter what happens. And the teams are going in hard. Just hear these words. The France family and NASCAR are monopolistic bullies. And bullies will continue to impose their will to hurt others until their targets stand up and refuse to be victims. That moment has arrived. That aggressive phrase takes place in the 24th paragraph of this antitrust case, which has temporarily overshadowed the 2024 playoffs. Since NASCAR's inception in 1948, the France family has maintained ownership of the organization. But how did we get here? Why is this only taking place right now? The NASCAR charter system was implemented in 2016 and was then extended for another 4 years in 2020. With the possibility of a new contract approaching, there was much back and forth between the teams and the sports administration. On September 6th, those talks came to a sudden end when NASCAR issued what the complaint described as a take-it-or-leave-it version of the 2025 deal, giving teams until midnight to sign or face losing their charters. 13 out of 15 teams agreed, but as we all know, 2 did not. But what happened next might have infuriated the teams even more. After 2311, Racing Tyler Reddick won the regular season title at Darlington, NASCAR executives were not there to present the trophy. You know, certainly, pretty disappointed to not see anyone from NASCAR present Tyler his trophy, said 2311 co-owner Denny Hamlin then. That was a little disappointing. The next weekend, during the Atlanta drivers' meeting, they recognized Reddick's accomplishment. However, too little, too late. The major theme of the 43-page complaint is NASCAR's monopolization of the sport and its aggressive measures to keep total control. The complaint claims that the France family operates NASCAR like a closed-door shop, wheeling and dealing its monopoly in smoke-filled backrooms. It cites NASCAR's anti-competitive restrictions in the charter agreement, which, among other things, prohibit teams from competing abroad unless approved by NASCAR. It talks about these practices in length, but this is perhaps the most important line about it. Because the owners of the 2016 NASCAR charter agreements were independent contractors, not the members of a joint venture operating a sports league, they were the most likely to form a computing circuit to NASCAR. By prohibiting them from competition in any other stock car races during the existence of the 2016 charter agreement, NASCAR further created a barrier to competitive entry which preserved its monopoly position and helps to do so through this day. As a result, NASCAR has all of the cards because the teams have no other options. The complaint goes into further depth about the several ways in which NASCAR maintains ultimate control over the stock car racing industry. It also mentions the sport's early days and Bill France Sr. as daring union-busting actions, but it also includes more modern examples. It also discusses NASCAR's $2 billion purchase of International Speedway Corp. (ISC) and its 12 race venues, as well as its acquisition of ARCA, the only other national-level stock car racing organization in the country. It goes on to say that NASCAR forces exclusive terms on racetracks as a condition of hosting a Cup Series race. It notes the adoption of the next-gen car as another method NASCAR kept an iron hold on the sport, describing it as an exclusionary requirement which locks premier stock car racing teams even further into NASCAR. The conclusion is that the sanctioning body now has even more influence since teams no longer build their own cars and instead rely on standardized parts and chassis given by NASCAR and its preferred vendors. Regarding the charter talks, NASCAR attempted to isolate owners through individual meetings and fought almost all efforts by racing teams to negotiate improved conditions. It goes on to add that the idea of completely abolishing charters was frightening to most of the race teams, emphasizing how economically disastrous it would be to participate without one. And this is only skimming the surface. The complaint spends the majority of its pages describing why it feels NASCAR is an illegal monopoly. Its principal argument is based on the Sherman Antitrust Act of 1890, which maintains the rule of free competition among individuals involved in trade while also preventing unjust monopolies. The complaint contends that NASCAR violated Section 1 of the Sherman Act, which prohibits contract, combination, or conspiracy by defendant in unreasonable restraint of competition. It also accused NASCAR of violating Section 2 of the Sherman Act, which addresses monopolization. The lawsuit seeks to have NASCAR found in violation of the aforementioned Sherman Act, as well as to have 2311 and FRM's preliminary injunction granted, which would allow them to continue competing as chartered teams in 2025 while the lawsuit is still being pursued and without being subject to any claimed release of antitrust claims. Essentially, they want to continue racing as chartered teams without having to comply to all of the rules laid forth by the sanctioning body, which they claim is lawful. Also, they want to pursue damages from the sanctioning authority. The action concludes with a demand for a jury trial. NASCAR has not yet issued a public response, but when they will, it will probably be a response the teams weren't hoping for. Fox Sports released an article Thursday outlining some of the anticipated procedures, including NASCAR's likely request to dismiss. If the sport's governing body takes that approach, one of two things will happen. The judge will either side with NASCAR and decide there isn't enough meat in the case to pursue, or he will side with the two teams and open the process to discovery. That's where things may get interesting, with both parties having to divulge massive amounts of data requested by the other. "We will be able to obtain financials," said Jeffrey Kessler, the attorney representing the two teams participating in the lawsuit. "We will be able to follow the money. We will be able to see exactly how exploitative this system has been and how much injury it's inflicted on the teams and the drivers. Because when the teams have no money, that also directly kills the drivers. The teams are the ones who compensate the drivers. It is a direct attack on both. And the last time I spoke to a NASCAR fan, the reason they love this sport is about the teams and the drivers. At least one individual with experience litigating against NASCAR feels the 2311 and Front Row team have a chance to effect change in the sport through the lawsuit." Fox Sports interviewed Sam Cherry, an attorney who represented Speedway Motorsports stockholder Francis Furco in an antitrust complaint against NASCAR in 2002. He said that he believes the case has a chance, especially since it puts NASCAR on the back foot. NASCAR is a very, very tough litigator, but that's not uncommon, especially when the core business itself depended upon prevailing on the antitrust complaint that we had filed, Cherry said. "Many of the pundits were calling me and asking me, 'Aren't you afraid that you're going to kill the goose that's laying the golden egg?' I said, 'Perhaps, but they've got a bigger fear than we do, and our people were risk takers.' 2311 and Front Row are now taking a similar risk, paying to litigate in the hopes that it would result in a more favorable environment for teams and drivers moving ahead. What do you think? Does the case stand any chance in court, or will the France monopoly continue for at least the next 5 to 8 years? Let me know your thoughts in the comments down below.